second, quorum is present. First order of business is to approve, a motion to approve minutes of prior committee meetings. Moved by Supervisor McGowan, seconded by Supervisor Stokel. All those in favor?
Aye.
Opposed? Motion carries. First up is District Attorney. Jason, you have the floor.
Thank you. So, I'll try to be brief. Sadly, after the last time I saw you, happy, sad news. Our third assistant was offered a job as an administrative law judge, and he has accepted that. So, Travis Brown has done a terrific job. He started as an intern in college, then he did 3 years of internships in law school, and then he was with us for 7 years. So, Travis is moving on to something really good opportunity for him. And with that, what we're trying to do is just slide all our people appropriately into their next roles, and Travis was the third, so I'd like to take my fourth and put him into the third. It's, I think, overall less financially impactful because of this new grid system that the county has created. I will still continue to have the same. I think there's a cost savings because of Travis's level of experience. But that's what I'm looking to do. It looks like a lot of things, 1, 2, 3, 4, 5. And then that would allow me hopefully to backfill that 7th position.
Okay.
I'll make a motion we do 1 through 5.
Okay, motion on the
Second.
floor, second by Supervisor Simpson. Any further discussion? And all of this, you will still have one vacant position at the end?
That is, so when you look at number 5, that's the request to fill that 7th, correct? And I've got 3 interviews lined up today.
Okay, very good. Call the question, all those in favor? Oh,
Aye.
Supervisor?
I'm going to say yes, but I just had a quick question for Jason. Jason, we did a salary restructuring a while ago. How much of this decision was a salary-related one versus just an opportunity-related?
Well, what he told me was that he's going to have the chance to make more money, work less. And he also, other happy news for him, I think he may be moving in with his girlfriend who lives in Clifton Park, which is not part of the residency that the ADAs are required to meet. So I think it was just, he said to me, he goes, honestly, she has children, I'm going to have less work, I'm going to have more time with them. And
All right. It's a lifestyle choice, not necessarily a salary choice.
I think it's sort of all the above.
Okay. Thank you.
Okay.
Aye.
Thank you. All those in favor?
Aye.
Opposed? Motion carries. And Jason, we had talked on the phone. Are you able to stay around a little bit longer, or do you need to go right now?
I just said.
Okay, thank you. Yes.
Can I make a point about the salaries?
Yes.
Just a point on the salary structure. I just want to bring out the fact that in this case, having that attorney grid in place actually saved money, because your employees are limited to the being out on the pay grid according to how long they've worked here. So in moving all of these people, essentially promoting them up the line in terms of succession, they all went to their appropriate pay level, when in the past, the way it was done was to incrementally give people raises by promoting them up through the existing salaries. So the old way this was done, the salaries would have stayed the same. The county actually, as a result of the budget, the amended salary schedule that we did at Friday's board meeting, saved some money. But the people in Jason's office that are getting more work got raises. So it kind of works out to the benefit of everybody.
Would you
I'll
like
make
to
a
make a
comment.
comment?
Yes,
Yes. Yep.
Thank you.
Vice Bramer?
Yes. I saw on social media yesterday a really nice comment about your staff, all the assistant DAs and Minot, our victim advocate, and I just wanted to thank you for all the hard work you do in your office, because it is very difficult. It was a sexual assault case, so it was a mother of a victim,
Okay.
a survivor, as she would like her daughter to be known, and I thought that was important to bring out, that you're doing really good work, and I appreciate that, and I'm sure you saw in the paper about our discussion about bail reform, and if there's any comments or updates
Supervisor,
since Friday.
we'll be picking that up a little later.
Okay. Thank you.
Supervisor McGowan?
Yes, just a quick question there. I see that District Attorney number 4 makes a little less than District Attorney number 5. Is that because he was here longer, or?
If you recall, when the restructure was made, there were sort of levels assigned to different responsibilities. And with Travis leaving, Ben is taking on more trial responsibility, and that position's also going to be taking on some of the trial work that Ben had been taking on. So I think that's why you see a slight change.
No, it is.
You might hear from me next year where I would be requesting another person to be moved from a 2 to a 3, but I'm not doing that now.
All right, I mean, I just want to make sure it wasn't a typo error in that,
No.
because
No, you're correct.
they seem to go in succession. All right, thank you.
Thank you, Joseph.
Something.
Next up is Office of Emergency Services, Director LaFleur, you have the floor.
Thank you, Chairman Leggett. This is quite simple. The first item is to update our contract with Capital Detronics. They're the ones that, the radio equipment work that we do not do. These are the gentlemen that do that, and we have to have a contract with them.
Okay.
And this is in the budget each year.
Moved to the floor by Supervisor Simpson, second by Supervisor McGowan. Any questions? All those in favor?
Aye.
All right.
Opposed? Motion carries. Next.
Number 2, resolution request to extend our existing contract with the Glens Falls Fire Department for our fire investigation series, The Cause and Origin. This is just an extension of what we've done for many years.
Moved by Supervisor Bramer, second by Supervisor Wild. Any discussion? I see there's a 4-hour call-in. Is that a contract thing? Yeah, okay. All those in favor?
Aye.
Opposed? Motion carries. Number 3.
Number 3 is resolution request to apply for the FY 2019 PDM. That's a part of the hazard mitigation scenario.
Okay. Who'd like to bring that to the floor? Supervisor Merlino, and a second by Supervisor McGowan. Any questions? Supervisor Simpson?
So the in-kind match, that's already planned, and that's
We
your
do the in-kind
existing-
match with the labor that is provided by the Soil and Water Group
Okay.
and our people. So we've never actually used cash for any of that. It's always done with in-kind service.
Thank you. All right. Call the question. All those in favor?
Aye.
Opposed? Motion carries. Number 4.
Number 4 is just to adjust the budget for number 3.
Who'd like to bring that to Supervisor Simpson, second by Supervisor Hogan. Discussion? Call the question. All those in favor?
Aye.
Opposed? Motion carries.
That's all I have, unless you have something for me.
Any questions for the director here? Supervisor Hogan?
I just want to say thank you to Brian. I spent some time with him yesterday. He very graciously walked me through what some of the sources of funding are for our fire departments, and gave me some good ideas for helping to look to the future as we lose volunteers. And so thank you very much for your time.
You're very welcome.
Thank you. Brian. Next up on the agenda is probation. Director Woodsey, you have the floor. Thank you.
Good morning.
Morning.
I have a series of resolution requests. The majority of them have to do with contracting for raise the age money. However, the first one is a little bit different. First one is to enter into a service provider agreement with Baywood Center. We do addictive thinking groups with our DWI and drug court participants, and having a group that involves addicted individuals, it's always good to have a KSAC involved with us, or somebody from an alcohol agency to kind of lead the conversation and issues come up. So Baywood has offered to provide an individual to our department at no cost. So we would like to enter into a service provider agreement with Baywood to continue the groups.
Moved by Supervisor Garrity, second by Supervisor Merlino. Discussion? Call the question. All those in favor?
Aye.
Opposed? Motion carries.
The next one is to enter into contract with Mediation Matters for restorative practices for the Raise the Age population. These are things that we put in our Raise the Age budget many months ago. Our contract with the state is finalized. So we are looking to enter into contracts with not only Mediation Matters, but with a few others I'll talk about in a second. The contract for mediation matters would be in the amount of $10,000. We would backdate it to October 1, and we would go to March 31st of 20 because that's the state fiscal year, and that's what we have funding to at this point. We anticipate that the funding that we currently have will be annualized by the state, and they will continue at the same amount going for the next state fiscal year, but we don't know that at this point. So they are presently working on that.
Okay, moved by Supervisor Garrity, and a second by Supervisor McGowan. Discussion? So this is a new program, and that you hope to then continue on as part of Raise Age. All those in favor?
Aye.
Opposed? Motion carries.
And the next one is, again, Raise the Age money with Warren County Employment and Training for Raise the Age. Again, this is a large amount of money. We worked a lot with employment and training regarding developing a program for Raise the Age population that involves training and work service. Again, this would start October 1, go to March 31st. Of 20, the contract amounts for $114,464. We obviously will not spend that much money in a short amount of time. However, that's the allotted amount. But we hope to have this one continue also in the ensuing year. So again, that ends with the state fiscal year, and we're hoping to be back to do it again.
Okay, moved by Supervisor Sokol, second by Supervisor Garrity. Question? Supervisor
Thanks.
Bramer.
Yep. What exactly are the programs and services that will be eligible through this program?
For employment and training?
Yes.
There's a sheet that they outline that's attached to this, that they're kind of their proposal, but what we're looking to do is refer 16 and 17-year-olds, and we can also refer younger individuals, at least to some training. This covers JEDs that would be, 15 or 16, they call that gap services, even though they're not youthful offenders yet. But what we would look to do is to provide equipment, job training, educational classes, and they would find job sites and pay them to do these kind of things, do jobs that they would have. So we broke it down into servicing many youth, as many as we could, as opposed to having a few that had 40-hour work weeks. So again, this would be a combination of training, education, equipment, and actual work and getting paid.
Supervisor Hogan.
I think this is a great program, and I support it wholeheartedly. I noticed that transportation to the task exam is provided, but it does not specify that transportation to the twice-a-week classes in preparation for task. I would just ask that as they move forward, there's some sensitivity to up-county participants and their actual ability to access these programs.
That's a great idea, and if we don't cover it in this, we put in additional money on ancillary services for transportation costs, whether it's locally with the bus, or if we needed to provide some other alternative transportation, whether it's cabs or things like that. So we built that in, understanding that we're a rural county, and the upstate and the upside towns don't have a lot of things because of transportation. Not only that, but with different types of services with alcohol, drug, mental health, but we don't have any down here either. But so that's a problem. We built that in.
Thank you.
Supervisor Bramer.
Going off of that, and your comment that you have more money here than you can spend, I mean, transportation to the job site. Kids can't get anywhere if they're only 15.
Right.
And don't have, support at home to get them there.
Right.
So maybe you can put in some money for cabs to get them that experience.
Yeah. No, and that's a good idea. And I think what we did when we developed these programs, we didn't know the population we're going to deal with or how it's going to impact us. So as we get into it, we can find out what's working and what's not working and make modifications. And the State Division of Criminal Justice has been pretty good to work with respect to the Raise the Age grant, allowing us to shift money as long as the common theme is there. So I'm hopeful that we can do all those things.
Mm-hmm. Good.
Supervisor Driscoll.
Thank you, Mr. Chairman. So when we're talking about cabs, we also talking about reimbursement for private individuals to drive, similar to like a Medicab situation.
Correct.
Okay.
To the extent that we include all that we certainly will.
Okay. Thanks.
And the age group on this?
would be 16 and 17-year-olds. That's our raise the age population, but we're also looking to incorporate younger individuals that would be charged with juvenile delinquent crimes, maybe as low as 14 or 15. Though they may not be able to work, they may be able to provide, they may be able to get some type of service out of this.
Good. Sure it meets a need. We have a motion on the floor. All those in favor?
Aye.
Opposed? Motion carries.
And the last resolution I have is to amend a service provider agreement we have with Big Brothers and Big Sisters for mediation. We did a service provider agreement with no funding in the spring, and now that funding is available, we'd like to include $7,500 again, going from October 1 to March 31st of 20. Surprisingly, we do have a few, so we are looking to reimburse Big Brothers and Big Sisters for their work. They're a fantastic agency. So.
Okay, moved by Supervisor Driscoll, second by Supervisor Bramer. Discussion? All those in favor?
Aye.
Opposed? Motion carries.
Nothing else on the agenda.
Thank you. Will you be able to stay for
Absolutely.
discussion? Thanks, Bob.
Thank you.
Yeah. Next up, the Sheriff Agenda. Major LaFar, you have the floor.
I did not, thanks.
Morning.
Good morning.
Morning.
We have a few requests for resolutions. First is a request to appropriate funds, $62,330. At the end of 2018, we had a couple purchase orders, encumbered funds, and the monies were spent in 2019, and the purchase orders were not rolled over, something that we just picked up this fall, and we're asking to appropriate $62,330 out of the general fund, unappropriated surplus, to cover that shortfall.
Motion to bring it to the floor. Supervisor Hogan, second by Supervisor Merlino. So, Jim, then those funds had rolled over into the fund balance of 2019, is that correct?
I believe that is correct.
That is correct.
Okay. Any discussion? All those in favor?
Aye.
Opposed? Motion carries.
We have a request for a new contract with the vendor First Light. We had a 5-year agreement with the Development Authority of the North Country for fiber service in 3 remote locations. For the first 3 years of that agreement, DANK covered the cost, or the state covered the cost of that service. They don't want to stay in as a provider to cover those monthly costs. It's another company who works with them, First Light, has agreed to come in, so we'd be stepping away from a contract with the Development Authority of the North Country and entering into a contract with First Light for a 2-year agreement of $25,200.
For those 2 years?
For those remaining 2 years, yes. The
Yes.
first 3 years were free to us, the second 2 years we have to pay for.
Motion for to put it on the floor. Supervisor Garrity, second by Supervisor McGowan. Any discussion? Hearing none. All those in favor?
Aye.
Opposed? Motion carries.
The third is a request to fill a vacancy. It's bittersweet. Communication Officer Cindy Roberts, with 28 years of service as a communication officer with the Sheriff's Office, will be retiring. Her last day will be the 25th, and I know it's not here yet, but we're asking to fill that vacancy when it comes due.
Okay. Moved by Supervisor Garrity, second by Supervisor McGowan. All those in favor?
All right.
Opposed? Motion carries. Thank her for us
Yes, sir.
on her years of service with the
Well.
county. Good.
There was a referral item. I'm not sure if I'm to bring it up or if there's going to be discussion, but there was a carryover, the purchase of 2 specific items, camera switch for corrections and some live scan software, something that's been discussed in prior meetings and it's still pending.
Okay. Do we bring this, was this out of a budget item to looking for, to do it now, once and done?
I just saw it on a referral again. I'm not sure if I'm... Okay.
We're done, right?
I think we discussed this, I want to say at the one of the budget meetings that we did recently, and we took the position of we'll wait and see how much is left over in the labor contingency, and we'll transfer we'll dedicate rather the remainder of that contingency to this. And in addition, Assemblyman Steck is working on a $50,000 grant to cover this equipment. So those would be the two funding sources. But I just don't know whether we want to handle this at budget or we handle criminal justice or finance, or I guess it's the pleasure of the chairs. They're all here.
Right. I think unless the committee has an objection, have it be at budget. Okay. Thank you.
Final thing is just a topic for discussion. The Treasurer's Office sends out a report, as you all know, and each month there's a notation in there under revenues for state aid claims. The Sheriff's Office we receive grants annually, pretty significant grants relating to communications, and the grants have gone unreported for several years to the tune of excess of over $1 million. I started working with a communications supervisor in our office, Derek Helms, really driven young man. He and I started to educate ourselves a little bit about these grants, started to learn the process of reporting, and really this young man put his head down for about 3 weeks and has gone in and reported every one of those grants that have been delinquent. They've all been submitted to the Treasurer's Office, and I believe at this point mailed to the state for reimbursement. So barring any errors or things that we may need to do to revise our submissions, I think it's safe to say that we'll be reimbursed in the near future for those funds.
Good. Thank you for pulling that together. Anything else to come before the committee at this time?
That's all for me, unless you have any questions.
No, but if you can stay around for a few minutes.
Yes, sir.
Thank you. Next up is Public Defender. Flores, you have the floor.
Thank you very much. I have 4 agenda items. The first is Distribution 8. I'm looking to get permission to accept the funding. The funding will go in next year. It takes about 6 to 8 weeks after the chairman here signs the contract, so we're looking for funding. It is for my office, and it is also for the assigned counsel office, and it's for $320,436.
Okay, brought to the floor by Supervisor Simpson, seconded by Supervisor Bramer. Any discussion? All those in favor?
Aye.
Opposed? Motion carries.
Thank you. Second item is to create a new position called Data Officer. This position is required to be created under the funding from Indigent Legal Services. What we're going to do is have an employee, we're going to create the position. It will go into effect on January 1st, and then we will have some funds go into it, and eventually it will be fully funded at the end of, in a few years, because remember we have the 5-year grants, and it gives us little increments all the way through.
Okay, so 2 and 3 are related?
Yes.
Marcy? Okay. Supervisor Simpson moves 2 and 3, second by Supervisor Bramer. Any discussion? Yes, Supervisor
Marcia, can you just remind me what the data they're going to be entering?
Sure. All the data from the assigned counsel office and the public defender's office. And they go into state reports for Indigent Legal Services. It will deal with any data collections that we do and the assigned counsel office
About
does.
the caseload and
Funding and paying for private attorneys who are on the assigned counsel list.
Okay.
The types of cases, there's a whole hierarchy.
slew of things.
Yes.
Yeah, right. Okay, thank
And
you.
it's one person from the county can only do it.
Okay.
And we have that person selected already, and the assigned counsel is supportive of that also.
Very good. Supervisor Wild?
Mercy, are we adding a new employee to county payroll?
It will be a new employee.
We can't share this with other people on your staff?
What's going to happen is the person who is going to be it is already on my staff, and her current position will eventually be decreated, and then all her funding will go into that, along with the Indigent Legal Defense Data Officer funding. So, because we don't have enough money right now to fund it fully, but because the duties are very specific, the Personnel Office felt it was important to create a title and position that was appropriate for the work that was being done.
So we're not actually adding a new employee to...
No, it's not going to be a new employee, correct.
Yeah.
But it's a new position.
I think you created a new word there.
Yeah.
Decreated.
Decreated, yeah.
Okay.
Yeah.
All right. Call the question. All those in favor of number 4?
Aye.
Or 2 and 3, excuse me. Yeah. Number 4 now.
Okay, number 4. The reason I bring up number 4 is my position ends on December 31st of this year. On January 1st, I believe, based on my experience of being in prosecution and defense for over 35 years, that someone will be arrested on January 1st, okay? That's my background. So if I'm not appointed or someone else is not appointed, then we don't have someone authorized to practice law to represent clients for Warren County, and I don't want us to be part of a lawsuit.
Okay.
Please appoint her.
I am proud to appoint Marcy at this time,
So,
thank you.
Yeah, moved by Supervisor Bramer, second by Supervisor Hogan. Administrator Ryan, did you want to speak to this?
Well, just a clarification on this one, and I also had a follow-up question on number 1. Sorry, it's late,
Oh,
but this
okay.
is an extension of the current appointment?
I'm sorry, I didn't hear your question, I apologize.
This is an extension of your current
Yes,
appointment?
it would be.
Yeah. And the extension is through?
Until the board meets in
Until-
January and does,
Yes.
and
Until they
decides
can-
what they want to do.
Right, until they can formally
Yeah.
reappoint you?
Yeah.
Okay.
Which would be
And
at
if they don't
our
reappoint me,
ordinance
that's your
meeting.
choice. Whatever it is, I'm good with.
Not sure what she's saying.
I know, but just a temporary extension until we meet in January for the form, okay.
That's
Yeah.
right.
I can amend my motion if you need that.
I don't-
No.
No, I think we're good here on that request, so. Okay, all those in favor of number 4?
Aye.
All right.
Opposed? Motion carries.
And I'm sorry, I thought, Mr. Moore, you had another question, and that's
sorry.
what I wasn't
Yeah.
focused on.
Just on number 1, are we authorizing the acceptance, or are we also amending the budget?
We're not going to amend the budget, because by the time we get the funds, it will be next year.
Got it, okay.
Because it's 6 to 8 weeks.
Okay.
So if we could just sign the contract, I'm happy.
Thank you.
Okay.
Yeah.
So those are all my issues that I had on the agenda. I don't know if there's any speaking points anybody wants to address.
At one point, actually, I've asked everybody to stay on here, as there was a discussion at the Board of Supervisors meeting for the county to take a look at bail reform and discovery. That has put us into a position as the district attorney and director of probation have informed us, and the sheriff's office as well. This is all going to affect us in how we handle all of this new statute, new law that is coming through as of January 1st. And there is a feeling among the board that it would be good for the county to put forth a unified voice in objection of some of these things and make recommendation. So I'd like to open it up to the floor right now. Marcy, we have not heard from you much on bail reform.
You have not. Are you interested in hearing from me?
Please.
Okay. I have some speaking points. The right to liberty and fair and speedy trial are 2 pillars of our democracy. For years, these fundamental rights have been neglected. People have been jailed for months based on their inability to afford bail, and in addition, the evidence that we would get a trial is held until the trial is right before it's supposed to occur. We wouldn't get it months in advance. The new statute will allow us to have that evidence within 15 days of arraignment, which would allow a client to understand what evidence is against them and to help their attorney to decide the strength and weakness of the case that the people have. Bail money is really used, it's supposed to be to make sure people are going to come back to court. But the problem comes is that my clients are indigent. So if you're saying that bail is going to be set at the amount of $500 over $1,000, many people in this room would be able to afford that bail. My clients cannot. They're indigent. And therefore, as a result of them not being able to make $500 cash bail or the 10% on a $1,000 bail, they are held in jail. And it affects their family because they often lose their job. They can lose housing. They lose child support. They lose services. They are not getting, and with all due respect to the jail, and it's expensive to have substance abuse, mental health, anger management, vocational education programs in the jail, and my clients are not getting that in the jail. The other problem that we have is that under the bail reform, people who are held on nonviolent crimes would be released, okay? However, violent crimes would be held. They would be sex offenders, something where violence is used, even if they're misdemeanors, if there's an order of protection. So there's a whole series of cases where bail could be set. The issue becomes, does someone willfully and persistently fail to appear in court? If Warren County is a rural county, and we don't have public transportation to all areas of the county. So if I have a client who can't appear in court because there isn't public transportation, the person who is going to give them a ride bailed on them. They have a child who's sick, or they have a family member that they have to take care of. They have a job, and if they don't go to the job, they're going to lose their job. And therefore, if they don't show up in court, under the old system, there'll be a warrant, and their bail will be set, and then you have this trauma created upon the family and upon the individual. The new statute that's going into effect talks about, in my opinion, willful and persistent failures to appear in court. And there has to be an inquiry as to what that is, and excuses. The court is allowed to hear what people are saying, why they can't appear, why they can't post bail. So the cost of the bail is also a factor that the court is allowed to inquire about. It used to be that the inquiry was only about, in terms of prior convictions. Prior appearances and failures to appear. The new focus is going to be on convictions, because based on clients' experiences, they have maybe missed court based on the factors that I talked about. According to, excuse me, I have a cold. According to the Chief Defenders of New York State, there's approximately 16,000 New Yorkers being held in pretrial jail right now, and what we're talking about, the majority is pretrial jail. Jail before they have been convicted of a crime. Jail to make sure they show up in court. And so, those, in terms of if those with financial
Marcy,
background.
if I can just for clarification,
Yes.
16,000 because they have not been able to post bail?
Correct. Cannot post bail pre-conviction, so they have not been sentenced. They have not been convicted of a crime. So the right to liberty and fair trial is an important factor that affects all of us in this state. In terms of, this is getting along, sorry. It is my understanding, and again, this information is from the Chief Defenders of New York State, that 89% of peoples in Rikers Island are people of color. 87% of the people in Rikers can't afford bail. Okay, so when we talk about upstate New York, the Chief Defenders of New York provided me with this following information for Warren County. In 2018, 62% of those behind the bars in Warren County were unsentenced, so they're waiting trial, have not been sentenced and not been convicted. And the unsentenced jail population increased 20% from 2017 to 2018. I have also figures from Shenango County, Portland County, Delaware County, Madison County, Oswego, and some other counties as well. But I'm not going to provide you with that now because it's not relevant to that. So detention increases a prosecutor's ability, in my opinion, to force the case to go a certain way. Because my clients are in custody, I don't have the discovery piece, and I don't know what those discovery pieces are going to be until the trial, which is trials usually in county court start on a Monday. We get the box on Friday at 5 o'clock, and over the weekend we're going all through this stuff. And Judge Hall's position usually is that 30 days before the trial, I'm not accepting another plea bargain. You're going to trial. This is it. So there's a lot of pressure on the clients to accept plea bargains, knowing what their exposure is for a case. There's a program called the VERA, V-E-R-A, Institute of Justice, in 2015 report that said that clients are far more likely to accept harsher plea deals and receive prison sentences or jail sentences because they're already in custody. And one of excuse me, I apologize. The Bureau of Justice Assistance, which is a division of the U.S. Department of Justice, found that those taken into custody are more likely to accept a plea and less likely to have their charges dropped because they were in custody. Right.
Take your time.
Sorry.
It's okay.
In Warren County, there's a pre-plea investigation. It is an investigation done by the probation department that allows someone to be interviewed by probation, and then they make a recommendation to the judge what should happen with this person. They look at lots of factors, where they grew up, family, education, employment, substance abuse, mental health, the crime, the victim, all those factors. It takes 6 to 8 weeks for a pre-plea investigation to occur. And often, if the offer is a 6-5 split, 6 months incarceration, 5 years probation, on a 6 months incarceration you do 4, then the client, if the pre-plea investigation takes 6 to 8 weeks, they might as well stay in jail, and because at least they know they'll get out and be on probation, as opposed to fighting the case all the way to see what's going to happen to them. Sorry about that. Okay.
We're getting you some water.
There's also something called charitable bail funds down in New York City, not up here. But that is a series of organizations, thank you so much. That is a
Thank you,
series
Matt.
of organizations that post bail for clients down in New York City. And again, the statistics from the Chief Defenders of New York say that they are 3 times as likely to get a favorable case outcome because bail has been posted for them and they are released from jail and they're able to aid in their defense better. They're able to provide documentation about their community involvement, their substance abuse involvement, mental health involvement, get them back into programs, get them to be part of the community. In addition, they also, the Chief Defenders of New York, indicate that 95% of those people who bail have been posted for them show up back to court.
What was that percentage, Marcy?
95. Okay. So the harm of cost to New Yorkers' families and communities by having people incarcerated means families are separated, children can be lost to foster care, people are not getting the supports they need, and it's, also, if you have a family member who's in the jail, the cost of the jail to get the collect calls from the jail are very expensive. They also have to figure out transportation to visit. Jail has visiting hours 1 hour a day on Saturday and Sunday, so they have to figure out their schedule. And often, clients can't get there, or their families can't get there because of their work schedule, because the rest of the family members have to work. And who's going to watch their children? So it's an ongoing problem. So I think, in my opinion, that the bail reform is a good reform. It allows for non-violent people to be released. In addition, the discovery reform is very important because it will allow a criminal defense attorney to know what the strength and the weakness of the case is so that they can discuss it with their client and have a legitimate expectation of what can occur and what won't occur. And it will move the cases faster through the system. One of the issues that has been said often is that the bail reform is all being pushed by down in New York City. According to the Chief Defenders of New York, the jail population in New York City has decreased from 22,000 to 7,000 over the past 20 years, and the crime rate has also decreased. When people are released from jail, one of the things my office is going to be doing, and one of the positions that you created for me, which I appreciate, is a social worker. The social worker will allow my clients who are in the jail and coming out of the jail to get services to deal with housing, mental health, substance abuse, vested programs, work programs, and without having those things set up, it's difficult. So I appreciate that. Bail, I believe, is a well-based system. I have lots more. An example, women in jails have a more difficult time because women tend to hold the families together. I know that's a little overboard at times, but in general, women tend to hold the families together, so when a woman is in jail, it makes it even more difficult on their family. When people steal basic needs, food, diapers, clothing, those are basic needs, and they still get charged. It could be a petty larceny, it could be a grand larceny based on the value. Usually it's petty larceny. So we have a scenario that happens regularly, in my opinion, is that people at the big box stores, Walmart, for example, someone steals something from Walmart, they have to get a letter saying you're never allowed back in Walmart. They go back in, they steal another item, which would normally be a petty larceny. But because they've signed this letter and gotten this information that you can't go back in here, they're now charged with a burglary, which is a state prison sentence, could be. So again, the people who have the least amount of resources are being treated this way. It's very upsetting to me and to my staff. So this bail reform has been very important because it's a big change. I talked about that.
Well, Marcy is taking just a breath.
Yeah.
Can I make a comment?
Please, Supervisor Kramer.
I said this on Friday at the board meeting. The bail reform for our residents, I think, is very important.
Mm-hmm.
We have lots of people who are poor and can't make bail, and I don't believe they should be sitting in jail.
Right.
Because of all of the indirect impacts that you just mentioned on their job, their housing, they're losing their ability to keep their family together, and that all, has a ripple effect that's probably way worse for our community
Right.
than them having stolen a box of diapers from
Right.
the store.
Right.
So I appreciate all that. I feel, though, that some of the reforms went too far in the respect of the carve-outs for violent offenses. I'm sorry, I'm not a criminal lawyer, so I don't know all the exact wording, but
That's okay.
and the example that we just had in the county, and I don't want to harp on that particular one, because there are others, like breaking into someone's home. That up here is a pretty big deal, and I think maybe you should consider needing to set bail on that kind of thing. And if someone is a flight risk, what's the ability of the judge to set bail? It's my understanding the judge now has no ability to set bail.
No, they don't fall within the specific categories.
Right, there's no bail.
There is no bail that is going to be set. I just want to give you some Warren County specific statistics.
Yeah, Supervisor Garrity?
There's a reason why these people are in jail. They were arrested, correct?
They were charged with something, yes, sir. But they're presumed innocent.
I don't want to walk out any second.
No, that's okay. They're presumed innocent.
Just
So-
because you've been arrested, Kevin, doesn't mean you're guilty.
Right.
I didn't say they were guilty, but they
No.
were arrested.
They
Well, the
were-
lady that stole from Walmart, she went back again and stole again. That's our problem?
Well, the client could have a mental health issue or substance abuse issue, or could just be in dire need and can't get services because there are time periods after you've been in jail that when services you have to wait to be reinstated for services again. So those issues apply also. I have from New York State Defenders Association. New York State Defenders Association indicates that 92% of arraignments that we handle right now would not be required to be jailed. Now, in terms of city court,
Under the new,
under the new, compared to what we have now. Just talking in terms of city court, 35% of the people who were jailed in city court would now be released under the new system, and 5% were released after paying bail within 5 days. So some people can pay bail, but it isn't instantaneous. It does take a while. So I thought those factors were important for you to know. In terms of all the bail factors, I obviously was not part of the drafting of the legislation, and I'm happy not to have been part of it, but I have to live with it. And I think that there are good changes in the bail reform. I think it's important for the people throughout New York State and rural people especially. So we were considered in this decision. It wasn't just downstate. And that was a concern that I was having, that people are saying it's only downstate. In terms of this is what the statute is, I don't see the statute, in my opinion, being repealed between now and January 1st, and we will have to deal with it. If there is a fact pattern that occurs, or a crime occurs, alleged crime, the decision by the prosecutor and the police are what to charge. If they can figure out a way to charge something that would require someone to have bail set on them, I believe in January they certainly would be doing that, because they would have the ability, because they would have all the facts and circumstances and know what was going on and make a learned decision based on that. So I appreciate you letting me speak. I know my position is not the popular position, but I appreciate you listening to me, and I do think it's good for my clients, and I do think that the trauma caused by an arrest and incarceration affects a family and affects a community, and I think, hopefully there'll be less trauma this way.
thank you, Marcy. Your voice is heard. You bring a unique perspective as a defender. Here, your office is one of the part of our criminal justice system that we have here, so these are all things that affect us. Your office has also has adjusted to the indigent legal services mandates over the years as well, so you've been getting a run-up to this as well as far as reform goes, so thank you for your input.
Thank you very much. I appreciate you letting me speak, everyone.
Yeah.
Thank you.
And thank you for the water. I really appreciate that.
Yeah. I'd like to call Jason up, the district attorney here.
So, sounds like he's in court. We call Jason to the stand.
That's right. So as the county looks towards impact on the county here, is there anything we should be looking at specifically or in general on bail reform and discovery?
Well, the first thing I would say in hearing Marcy speak about her perspective on this is, I agree with her. It's important that we hear all these perspectives. I think it's unfortunate that these weren't all brought to the table before these laws were made. So I know Marcy wasn't at the table. I know I wasn't. I don't know who was. I don't know what groups were. She's been quoting a lot of statistics from a Public Defenders Association. I know the District Attorneys Association was very interested in being heard because you can go with statistics, you can cite examples of problems with these new rules. And I always feel like it's good to try to think through things as far as you can to say, hey, what consequences might come from these decisions? So the law is what it's been made, right? I think we're all aware of that. And I don't think this, and I'm not to be flippant, but I don't think this is about someone stealing diapers. I don't think that's our big issue. And I don't think that's what this group's issue is. This was a huge reform that was made. When Marcy talked about discovery, I think what she meant to say was Rosario. Rosario was disclosed later in a case. Discovery, it's already in there. You're entitled to discovery. They make a demand, we have to give it to them. That's always been the law. So it's not that they get the case on the day of trial and they go, oh my God, I didn't know you had these pictures and this autopsy. That's all turned over. Rosario is different. In the new rules, Rosario will be a part of discovery. I think if you asked law enforcement and prosecutors, what is your concern on the discovery side? It's the timing. This 15-day timing is, many people I talked to said that's impossible, can't be done. I don't know what's going to be done. I've been talking with law enforcement, we're doing training, we've got training coming up in 2 weeks. I talked to someone this morning and they said, well, I didn't know it was this much. So I think there's just the way this law was created and the way it's been rolled out or not rolled out, so to speak, it's just been placed there, has put unbelievable demands on counties. As we all know, there was no funding that I'm aware of that they said, all right, well, and Marcy really talked about the harms to someone accused of a crime, who's got a job, who does some small crime, if they're jailed. Judges had the authority to choose when to set bail. Prosecutors don't set bail, defense attorneys don't set bail, judges set bail. In the example, with the diaper case where someone's employed, you would think that they would not have bail set on them, right? I would make that presumption. But maybe that was happening at some point. And if it was, that probably shouldn't be. What about the person who's now been arrested for the 19th time for stealing? Right? Is that someone who a judge should be able to look at differently? Not in 2020. That's not how it's going to be. That's not how the new rules are set up. So I think there's lots of things that would be and should have been debated and discussed. And then people who decide, and I'm not one of them, and Marcy's not, and would say, all right, this is what we think, now that we've heard it all, is the right decision. Maybe that all happened. I don't think it did, but this is what we have. So people have come to me and they give me scenarios. Someone this morning, an officer, he goes, well, what if someone's making crystal meth and they live in an apartment house and it blows up and it kills 9 people? I said, well, that sounds like 9 counts of manslaughter in the 2nd degree, maybe reckless endangerment. Those are nonviolent felonies in New York State. That is not a bailable offense. He said, well, what if they just came here from another country? I said, that's not a factor. It's still not a bailable offense. That offends some people, right? And I think some people think that's counterintuitive. Well, wouldn't you want your judge to at least be able to consider these factors when making decisions? So I think that's where what I'm getting from feedback from others is the concern that so much discretion has been removed from the judges in making decisions. Things that you would think logically, if any one of us was sitting in court and heard a case, they would go, oh, well, the judge probably should set bail. The person didn't appear or has a prior felony. They live in another state. They're accused of killing 3 people in a manslaughter case. I would think the judge might want to have some bail to make sure they come back. So not in 2020. We all know that. And I think that's where the concern is. The burglary example where someone who's has no ties to this community is found in a person's home committing a burglary. That is not a bailable offense come 2020. And that was specifically carved out. I mean, that was decided. It said violent felony offenses except burglary of a dwelling. So our lawmakers made that decision. I don't have any advice for the committee. I think these were things anyone would wish could have been really debated openly and discussed. It's not a debate between me and Marcy. It really isn't. I think we both want fair outcomes in cases, and we want whoever's accused to go through the process and be held to account for it, and not to leave the jurisdiction. I've known Marcy. I've worked with Marcy. I think she's probably of that similar mindset. So that's what I have to say.
Thank you, Jason. This is not pitting anybody against anybody. This is informing. This is part of the democracy that most of us here are town supervisors, and we all represent constituency here, and we come from a town to a county level, and if the county can also then speak at a town level, it should help inform that democratic process. And before Supervisor McGowan gets the floor here, is the District Attorneys Association statewide working on anything?
Yes.
Okay.
They have been since prior to April, just as I'm sure the Public Defenders Association.
And Public Defenders, Marcy, as well? Yes, okay. Yep. Supervisor McGowan?
Thank you, Mr. Mayor. What was the percentage of people that did not return to court that were set on bail? I didn't get that number.
It was 5%.
95% of
Yes.
returned, 95, so 5%.
5% did.
All right, that's 5% that set bail. So
Yes.
now we're going to go to no bail.
Correct.
I think that number will jump.
One of the things I think that's, I don't know that it's unique to us, but one, we are near the Canadian border, so we do get a lot of Canadians who come for tourism, for other reasons, to our state. We're border with Vermont, very close, as we all know. We have a large population that comes into the state and out of the state that aren't necessarily connected to the state otherwise, right? We have a great tourism here. It's the best county in the state of New York, right? Right? I mean,
Right.
Lake George, everybody
Right.
likes Lake George. So you're getting a lot of people who aren't necessarily tied to our area, and currently a judge can consider that on cases that aren't necessarily violent felony offenses when making a decision. Next year, if it's not a qualified offense, they cannot, that doesn't matter. So if you're from Florida and you come to Lake George and you get in a bar fight and you break a guy's nose, the court can't set bail on you. So that's just the way this is written, and that's a misdemeanor. If you commit a violent felony assault, then they can. But it has to be in 3 forms, and it's got to be the least restrictive forms, and there's these reviews that are permitted to the defendant in all cases. So, again, I remember when this was being touted maybe a year ago, and there was commercials, and you'd see a TV commercial with this guy who's got this job in construction, or he's working somewhere, and suddenly he's just been wrongfully jailed, and this has created this devastating situation. I'm sure that must happen sometimes. I oftentimes see people that are not employed. Some of them are homeless. They're addicted to various substances, and in the future, the court won't be able to consider. So you're homeless, you're heroin addicted, you were caught with a needle in your arm, we had to Narcan you, you fought the police, you have all these charges, it's a misdemeanor, you're ROR. I think there are unintended consequences that have come from that. I have talked to people who were addicted to drugs, who have gone through recovery, and some of them said, the best thing that happened to me was I was in jail, and I had no choice. I had no opportunity to use. I got clean, and then I got connected with a program. That's not going to be there anymore. That opportunity doesn't exist. Vivitrol is a drug that's been given to some by choice that helps them with their addictions. They have to be clean for a stretch of time before medically they can get that. That generally occurs at the jail. That will not occur. It can't occur at the jail anymore for people on non-qualifying offenses.
Thank you, and I'd like to finish this up by midnight, by 12 here for the next meeting, and I'd like to hear from probation and sheriff as well. So, any quick questions or comments?
It's always a quick question, at least I tried. Jason, Marcy mentioned something about 62% of our population is in pretrial. What percentage will it be after January 1st?
I don't think the current stats are, I don't think she was giving you 2019 statistics.
No, just 2018.
Right, so she's giving you 2018. I don't know who came up with those stats. I know that in the jail right now, how many people are in there?
We averaged for 2019, I had the numbers checked, way down. It was the average, right now we have 94 in the jail, which is really low for us, and we averaged for 2019 104. So that's very low.
Right,
Not
so-
for 2019, that's before the law started.
And some of those in there are serving probation, they're on probation violations, they're on parole holds, they're on arrests on different cases. Some of them are serving sentences, so.
Federal or federal?
And some are federal. So I don't want you to have the perception there's 100 people all sitting in there, or that there's 62 people sitting in there that fit under that category. This, in Warren County, this is not a huge number, but this is a state law. It's not a Warren County law, right? So, I don't know if I answered that.
Supervisor Bramer, did you have a question?
No, thanks.
Okay. Yep. Director Uzi?
Thank you. So working in probation, I'm not an attorney, so my perspective is a little bit different than Jason and Marcy. When this law was passed, our main concern in probation was that obviously we're probably going to be the pretrial service agency. Since we do pretrial, we've done it for 30 years. Pretrial is a small part of what we do in the probation department. With that said, with the passage of this law, as it was outlined, pretrial service agencies, at least at the time the law was passed, could potentially be responsible for supervising and notifying people of their court dates, where currently on our pretrial release supervision program, on any given day we have 65 to 70 people. So if you look at the misdemeanors that come out of our local courts, that's probably 400 or 500 people. So if we were tasked with being responsible for court notification of all these individuals, that's an overwhelming task that we're not set up to do. So that was our main concern when this came down. Since then, the Office of Court Administration has indicated they will take responsibility for notification. They haven't said how they're going to do it or what that actually means, and that's probably concerning to a lot of courts. Does that mean in our local courts are the court clerks responsible for that, or is OCA as an umbrella, as a large agency looking to do that? They haven't explained that. I believe what they're looking at is a program that's operated out of the Criminal Justice Agency in New York, a large non-for-profit agency that only does pretrial. They do these things already. They do court notification. They do all that stuff. So I think OCA is looking to say, how can we take their program and turn it into a statewide system? So they're working on that. They really haven't come out with specifics. Not that it's OCA's fault, but there's just a short turnaround time between when this law was passed and implementation. It's not like Raise the Age where we had a year to plan, even though that was very short. At least it was a year. This is just like, here it comes, and we still don't have a lot of information. So from our perspective, that was a big concern. So if we're not tasked with doing all that, well, that's some pressure off us. But what does that mean for our local courts, and how do we deal with them? We have a tentative meeting set up November 7th with our local magistrates to talk about bail reform, to get their ideas and to tell them what we're prepared to do. So even though OCA has indicated they will do notification, I don't necessarily think that gets the probation department locally out of it, because we've assisted our courts to the extent that we can. So we have to see how that plays out locally. There's different things I hear going on, how the court plans to do it. But again, we don't know. The other thing from the probation perspective, if you're a pretrial service agency, they talk about electronic monitoring. Very few people in Warren County are released at the time of arraignment under electronic monitoring. We use electronic monitoring for adults. There are some release cases. We use it frequently as a sanction for courts, an intermediate sanction. If not for this, this individual will do some time in jail. So we utilize it that way. So the statute says for electronic monitoring, it has to be done by a county entity or a non-for-profit. There are no non-for-profits that do it, so that's out of the equation. And to expect the county to pick up electronic monitoring, that's an expensive proposition. Washington County, a similar sized county as us, does electronic monitoring. Their budget's probably $50,000, and that's very limited. With that said, for electronic monitoring, I've sat through and listened to many things since April, trainings, different perspectives of different people, from electronic monitoring being you need to have a qualifying offense to get it, meaning a felony or a domestic violence misdemeanor or sex offense, to others to say, well, if an individual doesn't show up for court, repeatedly and they're found to be willful and persistent, as Marcy and Jason talked about, you can do it after you've done those things. I'm not sure what the answer is, and I think a lot will be decided by case law. But locally, so if we talk about our felony cases, I don't think out of our county court we'll get many electronic monitoring cases. We get a lot of release under supervision cases from our county court. That's how Judge Hall operates, so we're already in the business of doing that. And how it transports into the local courts would be another question. So from our perspective, the notification and the monitoring were the big things, and we pushed the state, and we do through NISAC, that 100% of the cost be funded by the state for probation services and any pretrial services associated with that throughout the county. That goes for the district attorney adding individuals to deal with this, the public defender, assigned counsel, the sheriff, and anybody else. So that's been our big push. Having done pretrial for 30 years, the figure Marcy talked about, 62% of unsentenced inmates in the jail, seems to be consistent for Warren County. Of those 62, as the sheriff talked about, you'd have to drill down and see who's boarded out, who's on a parole hold, who's there on a voluntary commitment, and then get down to figure out what those numbers are. I don't have them off the top of my head, but that may be worth it to look at sometime to say, of that 62% or 61% of unsentenced people, how many are eligible for non-monetary bail? And just moving quickly, how this will affect our department. Typically when we do pretrial release, we were in the business of interviewing people in jail, or at least screening them, and providing meaningful information to the courts through a failure to appear screen, a risk assessment. Will this individual come back to court? We used the Compass risk assessment developed by North Point, Criminal Justice Agency. Most of the people on our failure to appears are low. Sometimes I look at it and say, how does this happen? But they're very low, which means the likelihood of them coming back to court is great. So the interesting part now is we're going to go from being a department that provided meaningful information to the courts to being a supervising agency for people put under release under supervision and people calling in to a notification agency to some degree. The other interesting part, the law says you have to have a validated risk assessment. For judicial decision making, there are no validated risk assessments in the state of New York. Compass isn't validated in the state. What they use in New York City is not validated in the state. So people have asked me, what do you do on January 1? We don't have anything. No one's given direction. A couple other things. The pretrial standards and guidelines have not been released yet. Those, when the state typically promulgates a law, they provide guidance and regulations of how that would operate. We know what the law says, but the law can be interpreted many different ways. But if you have guidelines and regulations, if you're a pretrial agency, it focuses you on what you need to do. They have not come out yet. They're supposed to come out this week. So it gives us very little time to look at that and dissect it. We're at the end of October, so we got 2 months to pull this together. So from my perspective, if I'm not responsible for fully doing notification and electronic monitoring, it's not a huge burden to the county, we'll make it work. We already have a we already have a release under supervision in place. We have a dedicated call-in number where people call it, we check it, we record that information. If they don't do what they're supposed to do, we notify the court. We see people. So if the capacity doesn't go up a tremendous amount, we're set. I mean, who knows what happens come January 1. I think if the county's thinking about doing a resolution of any type, I guess the question would be, when do you want to do it? Do you want to do it before the law goes into effect, or do you want to wait till afterwards to pick out the flaws that maybe are coming through, to say, we've had an incident here, obviously, where an individual was killed, and if not for if this law was in effect, he would have went. There'll be many more of those that probably happen in the state. So is it better to wait until after January 1 to do a resolution, or do you do it before? I mean, those aren't my decisions, but those are questions to say, do we want to do it now, or do we want to wait to see what happens for the quarters? So those are just a couple of thoughts.
Thank you. And we don't have an answer for that last question.
Thank you.
there.
Neither do I.
Thanks, Bob. Sheriff York.
Yeah, I think I'll let Jimmy broach the police end of it,
Okay.
because he's gonna have to deal with it in January. I do want to make before Jim, I want to mention about the jail, just some thoughts. If you recall, you built a new jail some 14 years ago, and the reason you built the jail was because your jail population was up over 100. And the Corrections Commission mandated that you have space for your people. So you took on the $24 million budget and you built the jail. We've been averaging in the 12 years I've been there probably anywhere from 120 to 140, as high as 170 people in the jail, right up until about a year and a half ago. As I said earlier, the average for 2019 is way down to 104. So if Marcy's numbers are correct, 62%, I'll even go 50%. If you go to 50%, people, and I haven't looked at it, we can look at it and see how many people are going to get out of jail January 1. I'm sure it's going to be a big number. We can publicize that, who's getting out and what they're in for, so the public at least knows what they were in for and why they're getting out. But if you take the 62%, and I'll make it 50% just to be a little bit safer, you're going from 104 to in the 50s. Now you're in the 50s in the jail. And if you also recall, we had staffing analysis that the state said you got to hire 13 more corrections guards, which we did some 7 years ago. So what's perplexing and troubling to me is the fact that they're not going to tell you you can fire some of these people or get rid of positions. They're going to tell you the jail is the jail. You got 186 beds, and that you still have to employ the same amount of posts, whether there's 50 people in the jail or whether there's 102 people in the jail. So your expenses are going to be the same. You know, your $10 or $13 million for the jail is going to be the same, and they're going to be watching 40 or 50 people. To me, that's troubling. I think the state, before they mandated everybody to build these jails, they should have probably done bail reform first. And we probably could still be in the old jail. The only thing you'd have to be worried about is getting asbestos out of it. So that's my thought on that. And Jim, I'll let you broach the police end of it.
Yeah, thank you, Sheriff. Major LaFar.
We appreciate Marcy's passion, and I respect her position. From a public safety standpoint, this is very alarming. I know I've said it before. I'm not going to echo much of what was shared, but from the sheriff's perspective, Jason's timeline is 15 days, which means at the sheriff's office, we've got maybe at most, we've been discussing this, about 5. So with every arrest, there's a number of forms that are generated. And our officers work 12-hour shifts, so if they handle a call today, they may be off for 3 days subsequent to that. So by the time they come back in, we're really short on that timeline. We have to get what we need to Jason's office so that he can receive, review. There may be issues with the paperwork. So discovery, the 15-day time period, it's going to cause a strain and an added expense to the sheriff's office, so I just want you to be aware of that. The bail reform, I know that that's alarming as well. To think of it, put it in perspective locally, I know we have an issue with our factory outlet stores. We have a number of people from downstate who come up and shop, and they fail to bring their money with them. They steal on a regular basis. When these career criminals learn that they can come here and steal from us, go back downstate, and that they're not going to be any bail set, and if it is, are we really going to work diligently to bring them back up here? That crime is going to spike even more. There are going to be a number of things that come. They're going to come our way. I want to assure you that we will work together. We will work with whatever laws are in place, and we will be successful. Just have to work harder.
Thank you. Supervisor McGowan.
Well, to lighten things up here, all the TV programs that I watch, they're able to do everything about 45, 50 minutes. So.
And they got video of everything. In 43 years, Brad, I've had one video of a crime scene.
Really?
One time. And that just happened recently. But, you know, that's Hollywood. That's not reality.
No, and I just said that to lighten it because it's very alarming and what's coming down, and none of us know. And you guys who sit in the position where you should know a little bit more, you don't know, and we're going to have to work together.
The scary part for all you folks in this room, I really think it's going to be in the jail, because that's a huge expense. And it's gonna be like, you see hotels closing down because there's no visitors. If you're in the 50-40 range, you're gonna have to go back to the state and say, okay, you've gotta change your rules on mandated positions, let's go. And it won't be just Warren County, everybody's screaming, and we've had meetings at the Sheriff's Association, they're in line with these trainings as well, so,
And,
scary.
yeah, so Sheriff or Jim, on sheriffs for advocating, is there anything going on now in response to this bail
There are-
reform and
yeah,
discovery?
there are, the Sheriff's Association, and I've missed a couple of the meetings, but they're having meetings now relative to this, and I think they're in line with district attorneys and the chiefs of police, so they are meeting.
Good. Well, Supervisor Wild?
Mr. Chairman, from what I've heard, I think there's some positives to this new legislation as well as some negatives. But I think it's important that we put a position to the state quickly instead of waiting until after it's implemented about the tragic situation that we had here. And I don't think we should delay to fill up 4 or 5 notebooks worth of examples. I think we have a real-world one that's troubling that we need to get in front of the state to see if we can do something about it, having them either delay or make some quick modifications.
What's the committee's pleasure? Supervisor Bramer?
Well, we have, there's inter-county Thursday, right? Inter-county.
Thursday, yeah.
And then, there's always, we could go to NISAC through the Criminal Justice Committee and ask for some, because it sounds like they're not doing a whole lot.
Yeah, I believe up to now, they have not taken, if anybody knows better, please correct me, but they haven't taken a position one way or another on the merits from a criminal justice perspective. They've said that what the state needs to do is fund it.
That's accurate. They've taken that position that it needs to be funded, though I believe behind the scenes they're working on pointing out certain things, such as 15-day discovery, certain things like that, to say these are just not going to, unacceptable.
Well, and what about the
Hold on, just one sec.
standards?
Bob, that's from being on the task force, you hear those things? Okay, thank you. Supervisor Bramer?
Sorry, and are they doing anything to advocate for changes to the sheriff, the standards of post, yes?
As the sheriff talked about, they always talk about you're going to see savings in the county, so it's really not going to cost you anymore. They pointed out in NISAC that that's not, there's no way that's going to happen.
not
If
true.
we ever see any savings, you're talking 3 or 4 years down the road. Because of the staffing requirements and all you have to do. So they pointed out to the state that that's not realistic. We are not going to see any savings.
Yes. One more,
Okay,
Supervisor
sorry.
Bramer.
And, I mean, I'm not a town supervisor, but won't this have negative impacts on the town revenue through the court? I mean, not like we're trying to make money
Yeah,
off
that's-
people.
that's
but-
We lose money every
but it's
year.
not-
Right.
the whole-
The
My
concern
point
here.
is, it's not gonna save us money. We still have the same cost as the county to run the jail for 150 people when we only have a third of that in there.
Yeah. Supervisor Sokol?
Thank you, Mr. Chairman. In light of the time, I would have to agree with Mr. Wild. I think there's nothing wrong with sending a resolution through now. We can always authorize another resolution, or 2 resolutions, or 3 resolutions later on after we see what the implications are. So,
Okay.
Just
I
some-
agree. Jason?
Just one thing I would say, because you're trying to come to some decision-making. When you look at felony offenses, and they selected violent felony offenses, there are offenses that I think people are looking at going, well, you just would assume it's a violent felony offense. There are many homicides that are not. Criminally negligent homicide, manslaughter in the 2nd degree. The vehicular homicides are not violent felony offenses. That's maybe a starting point from what I'm hearing in this room, that maybe those should be ones where a court could consider bail, where there's a death, and there's an allegation. Maybe you have other things in mind, but certainly there's a whole list of homicides that will not be eligible for bail in 2 months.
Okay. Supervisor Driscoll?
No, I'm all set.
Okay, Supervisor Bramer?
I was going to say, just quick, as a course of action, instead of passing something today, maybe asking our professionals to put
Yes.
something together with respect to suggested changes and having Marcy's input on that as well, and then put something together.
I can
Yeah. Yes, Supervisor Hogan?
I'd be more comfortable seeing what we're passing a resolution on before we just send out a blanket statement.
That's right. I don't think we're in a position to do any statement at this point in time. This was for us to be informed and see where to go from there. Supervisor
Thank you,
Driscoll?
Mr. Chairman. My point was similar to that. I think there's strength in numbers. I know that Assemblyman Steck has already taken a position on this, and I'm sure that Senator Little is in the process of doing the same. Let's bring everyone to the table before we draft anything.
Okay. Who shall be in charge? Administrator Ryan, Moore?
I can get a meeting together and we can start working on it.
Great, thank you. Do you need people appointed for that meeting, or?
If
will
you would
we-
like it, it's totally appropriate if members of the committee want to be involved.
So, who would like to be we need 3 people to step up
Pick me.
for Supervisor Hogan. Yep, Supervisor McGowan, Supervisor Bramer. There you go. Thank you. Any other business come before the committee at this time? Entertain a motion to adjourn. Supervisor Wild and Supervisor Bramer, all those in favor?
Aye.
Thank you all for coming.
I'm just curious, I'd be interested